court cases on land properties. Then we have some in the police station. We even have some, there's even one presently I'm handling that has to do with landed properties, contention. I'm the owner, I'm not the owner, I bought it from this person, I did not buy it from this person. You understand? So in order to enjoy peaceful possession of your property, free from all encumbrances, when you are acquiring a property, you must follow the necessary steps, necessary documents. Most people, because they don't want to pay a lawyer's fee, they skip the process, and at the end they start fighting, or they get themselves into this argument with another party, and before you know it, the case is taken to court, and it's just there, and nobody has access to the land. That shouldn't be so. So to acquire landed property, you need to take the rightful step. You need to consult a lawyer. You need to do a search report. They need to do their investigation to show that, okay, truly this land is free from all encumbrances and you can enjoy peaceful possession of it. So please take note of that. So back to deed of assignment. Like I said earlier, that deed of assignment is a transfer document that transfers title of ownership, title ownership to another person that is acquiring the land. So it is a document like this. What are the things that are written, or what are the things contained in a deed of assignment? A deed of assignment, it is a very valid document to prove ownership of land. So a deed of assignment is divided into three parts. We have the introductory part, we have the operative part, and we have the concluding part. Now, what is the introductory part? Excuse me. What is the introductory part? The introductory part is just the introductory part contains like the preliminary details, the preliminary information you should know for every agreement. I mean, for every agreement, when you open an agreement, the first thing you should see is the commencement date, the parties, and probably the background, right? So it's the same with a deed of assignment. We have the commencement date, when the deed of assignment is taking effect, like the effective date. Okay, this agreement is, this deed is made this dash day of dash 20 dash, or whatever year it is. And between, then we have the parties. The parties must be legal entities. They can either be natural persons like an individual, or artificial persons, that's corporate bodies now. You know, corporate bodies, they are recognized as a legal entity under the law. So it can be natural persons, it can be corporate organization like that, just to acquire a property. Of course, must be of a legal age, if you are an individual, and with your full names, the addresses, and your status. Status now is who is the assignee, who is the assignor. Yes, you get to see something like that. Okay, assignee, assignor. So assignor is the person that is transferring the title. Is the owner of the land, but is now transferring it. Assignee is the one that is receiving it. The assignor and the assignee. So if I'm the owner of the land, and Mr. B is coming to me that he wants to buy the land, okay, fine, I want to assign my title, right? I want to transfer ownership to you. So I am the assignor. I am the one transferring title to him, who is now the assignee. So these are the standards that must be stated clearly. So instead of using the person name in the other parts of the document, because definitely you want to make reference to the parties. So instead of saying, okay, you said Mr. Jide Alao and Mrs. Ngozi Chukwudi. These are the two parties. So furthermore, when you are drafting the agreement, you can't begin to say, okay, Mr. What's the name I called just now? I've forgotten. Mr. Alao is saying, if Mr. Alao wants to transfer, then when you want to make mention of Mr. Alao, you say Mr. Alao, Mr. You understand? Repeating Mr. Alao, no. So you can just say the assignor wants to transfer to the assignee. So once you've differentiated it from the beginning, that Mr. Alao is the assignor, Mrs. Ngozi is the assignee. So you can just say from here on we are using assignor and assignee. So when you see assignor and assignee in a deed of assignment, you shouldn't get confused. We are just, instead of repeating the same name, imagine if it's a company. So you can't just keep repeating the company name. I'm trying to come up with a company name. Let's say Tosfem pharmaceutical company Limited or something like that, no long name like that. So you have to make reference to the company. Will you start writing Tosfem Pharmaceutical Limited all the time you want to make reference to it? No. So once you've written it out, right, Tosfem Pharmaceutical Limited is the assignee. So you can just continue that the assignee, the assignee, the assignee. So that is why we use terminologies like that. I hope that is very, very clear. So the parties must be legal entities, either natural or corporate bodies, with their full names, their addresses, and their status. Then under the introductory part also we have the reciter or the background. Now this is the part that gives us the brief, the material facts of the transaction. The material facts of the transaction. I have a sample of a deed of assignment here, and I will read that. I will explain to you how it looks like how it looks like. When you talk about the background, it's just giving you the details. Okay, this person is the owner of the land. He bought it or he acquired it from inheritance, or it's a family land, and is willing and ready to transfer title or ownership to so or to the assignee. You understand? And the assignee has agreed to acquire title. So when you mention the background is just giving you or we call it recital anyway, that the background or the recital is giving you more like a brief summary, just the material facts. Okay, what is happening? What is this agreement all about? Okay, this agreement is all about the assignee, Mr. D, who acquired a family land or who inherited a family land, and he wants to, okay, the land is 40 acres, is covered by a survey plan, is located at this person, it belongs to him, which he acquired from his father, and he wants to, and this said land, he wants to transfer it, or he has expressed his desire to transfer all the interest of any particular interest wants to transfer all the interest of the land to so and so. So it's just the background facts, the material facts. What is the agreement all about? Somebody wants to transfer something to somebody. So that is it. So it just traces the background of the property, just give us a detailed information about the property. Let us know where we are. Let us know this property. This property that we are buying, this property that I want to buy, where is it coming from? So it's just like tracing the roots and tracing it. Okay, fine, the property is for this person. How did this person get it? It's tied to, okay, he got it from, it was inherited, or it's a family land, it's a principal member, other family members are aware, you understand? So just like a brief summary. So that's on the introductory part. I said there are three parts. The deed of assignment is divided into three parts. I first about the introductory, which includes the commencement dates, includes the parties, includes the recital. Now let's go to the operative part. The operative part is more like the body, like the engine room, the most important part. In fact, that is the most important because it's that part that is transferring the interest. The background is saying that this person wants to transfer. The operative part is saying this person is transferring. So that operative part is like the engine room, the most important part of the agreement, where interest is passed, like that. So that is where we have the consideration. Consideration is the money, the price involved. Okay, in consideration of the sum of 15 million naira for 40 acres of covered by so blah 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 blah. Don't let me do blah blah blah. Let me just give you like how it's written. In consideration of the sum of so million naira paid by the assignee, also the assignee. You see now, paid to the assignee by the assignee. So it's like that, okay, fine. 48 million naira has been paid by the assignee to the assignee. There is the receipt. You understand? There is the receipt. So because of this, the assignee is hereby assigned. The assignee assigns all everything, all the interest. If it's all the interest you want to assign, or whatever interest you want to assign, all interest or it's also interest to the assignee. So that is the most important part, but that is where the interest is being transferred. Okay, the land, 40 acres of land, 50 acres of land covered by survey plan, deed of certificate of occupancy, like that. You understand? So that is the most important part, where the assignee is saying, I am this person has paid, he has he has done the needful, he has paid his dues, the consideration, he has fulfilled the consideration. Now I am assigning my interest. I am no longer the owner, he is the owner. So the operative part is the most important part of the deed of assignment. So under the operative part also, so we have the consideration, we have the description of the property, how many acres, how many hectares, the survey plan number, the name of the surveyor, the address where the land is situated, everything about the land. I am transferring it to this person. So that is it. Then we have the covenant. The covenant is the obligations of both parties. The obligation of both parties. Okay, the assignee is saying that, the assignee might be saying that, okay, fine, when I buy this land, I will be responsible for paying all future rates, future taxes, assessments, duties, charges, whether from local or state level, imposed on the property. So the assignee is saying that this is my obligation. Now that I've bought the property, this is what I am obligated to do. And the assignee also has his own obligation. The assignee can say, okay, fine, he comes to, the assignee say that they have a good title, there is no encumbrances, they have done whatever they have to do, they don't have anything. You understand? So they are listing their obligation on the property like that. If it's a family land, the assignee in his covenant can say that what he has the consent of the family to the consent of the family members to execute the documents and transfer ownership. And the assignee can say, fine, they don't have any interest in the land again. This the assignee that has, the assignee can enjoy the property, can enjoy peaceful possession without any interruption. The assignee is saying that I am not going to interrupt their peaceful possession, I have handed it over. So just different obligations and covenants, terms and conditions like that are due on both parties. So like I said, the operative part is the most important part. Of course, the other parts, they are, of course, I mean, if an agreement is not dated, it's invalid. If it's not signed, it's invalid, right? So every part of the document is very important. It's very, very important. It's just that the operative part is like the heart of it. I am transferring. But of course, no matter, even if you have the operative part, you have everything, and it is not signed, it is not dated, it is just a mere piece of paper. You cannot even rely on it in the court. So every part of the deed of assignment is very important. That's why you must take notes whenever you are executing a document. Make sure the necessary things are done. We have the concluding part, and the concluding part contains the testimonium, the execution, and the attestation. Now the testimonium is where all parties, it shows all the parties that are involved in the deed of assignment. Okay, in witness of which both parties have executed this deed, this day and time below. You understand? That's testimonium, saying that all the parties that were listed in the agreement are the ones that are executing this agreement. So it's more like the parties testifying that yes, we are the ones that executed this agreement. That is the testimonium. Then we have the execution. When they say a document is being executed, it means that what is just signing. You are signing. So signing, very important. I mean, if you don't sign a document, it's just a mere piece of paper. I mean, it's not binding on everybody. Me signing a document means I'm appending my signature. I am saying that yes, I am the one that is agreeing to these terms and conditions. So if there is no signature, if there is no execution of the document, then it is just a mere piece of paper. So the capacity of the party is of great essence in the mode of execution. So if it's a company that is involved, 2 directors can sign, or a director and a secretary. And if it's a party, of course, an individual can come and sign like that, and an individual can come and sign. So there are different ways you can execute a document. There's different ways you can execute a document. Anybody that is an illiterate that cannot write can use his fingerprint to just stamp it like that. Just a proof that yes, I am the one that is signing this. I have agreed to these terms and conditions. So we have execution and we have attestation. Attestation refers to the witnessing of the execution of the deed by witnesses. Attestation is saying, okay, fine, who will attest to this execution, who will attest to the fact that these people actually signed the contract. So attestation is witnesses also coming to sign that, okay, fine, we are there when so and so person signed this deed of assignment and transferred ownership of title, ownership to so and so person. So attestation is very, very important. So basically those are the important clauses in a deed of assignment that you should take note of. Make sure your deed of assignment is dated, it is signed. You know, there's something called signed, sealed, delivered, right? Exactly. So once it has gone through all this, then it is a valid document and can be tendered in court in the event that there are disruptions or contentions as to who is the owner of a particular property or land. So I hope we've learned one or two things. Don't forget to like our page, don't forget to subscribe, don't forget to share, don't forget to comment. If you have any questions, you can drop your questions and we will attend to it. Thank you so much for your time. Thank you for joining us. My name is still Oluwatosin Isaac on Accent Reality. I will see you next week. Same time next week. Bye.